Meanwhile, with me in studio, we do have a lawyer, Peter Wanyama, and we're just looking at some of these occurrences. And let me start with the brief that we've just received there from Mutula Kilonzo Jr. For him calling for fresh elections by virtue of the fact that they say these particular elections are a sham. Is there room for that?
So far as the Constitution is concerned, there is no room for IEBC to conduct a fresh elections based on the allegations that the ICT system was maintained by IEBC was interfered with or hacked or accessed and then the results altered. The only circumstance where IEBC can call for a fresh elections are only two. One is where none of the candidates meets the constitutional threshold, in which case we'll go for a runoff. So a runoff is like a fresh elections. But of course, it is limited then between the first and the second.
And this is if they didn't garner the 50,
exactly.
50 plus one.
In this perspective, then the constitutional threshold then was not met. That is, the winner didn't get 50 plus one. And of course, also, he didn't get 25% of the vote in at least half of the counties. The other scenario is where the person who will have been declared president dies before the final declaration, in which case then IEBC is entitled to cancel the presidential result and call for fresh elections. Those are the only two circumstances anticipated by the Constitution where fresh elections may be held at this point in time. That is, in this case, the death of Uhuru Kenyatta, and because based on the votes, most likely is going to be the one to be declared president. So if something happens to him, then we do a fresh elections. And of course, if they don't meet the threshold. So there's no room in law. I think NASA is stretching this issue far. Jakayo Midio has explained it very well. It is really important that they follow the legal avenues to address whatever claims that they may have, so that we move this matter to the next level.
Okay, so in the event that possibly the system was hacked and the results compromised, what then would be the way forward if it's not fresh election?
If the system was hacked and there is evidence on record, in this case the matter is now before the Supreme Court, then the Supreme Court will make a determination as to whether that hacking actually influenced the presidential outcome, the presidential results. And if it was done in a major way, then the Supreme Court has discretion and indeed constitutional powers then to nullify the entire presidential election and call for a fresh
election.
Order for a fresh
All right,
election.
but of course that then again would be a process which they have to go and prove legally that this
absolutely. And this is an issue which I think is scenario dependent. It's an issue which requires technical expertise in the sense that NASA, and here I remember they are trading on a very, very dangerous path. Dangerous in the sense that hacking of an IEBC website is in itself a criminal offense. So how did NASA get the evidence they claim to have gotten? If it was that, if the evidence was extracted by an employee of IEBC, that is a criminal offense. If the evidence was extracted by somebody externally from NASA by accessing this IEBC website, that is a criminal offense. So that issue is going to play out later on in the presidential election petition, if at all that evidence is coming out.
Just by virtue of the fact that how did they get the evidence of the system being hacked?
Exactly. How did you get the evidence that the system has been hacked? The logical implication is that you may have accessed the system yourself for you to make those inferences and conclusions that the system was hacked.
Or have somebody who has access to it who availed it to you.
Yeah,
but
exactly.
isn't there a legal provision for you to have that? Because one of the questions that was asked to Raila Odinga yesterday as he was doing that, Honorable Raila Odinga, is the source of the information. But of course, his answer was, we are protecting the source. We are protecting our source of the information. Is there a legal provision for that?
I think he was careful not to mention the source in view of those legal implications. Because if it turned out indeed that you access the system and there is evidence that, that actually the system was not hacked and that the system is secure and concrete, then you have committed a criminal offense. So you'll be exposing that source to a major criminal offense. In this case, conviction for 10 years in prison or a fine of 10 million.
So now, should there be evidence alluding to the fact, or should the evidence be credible? Because they've already presented what they have said is evidence, alleged evidence of the hacking and even the timings and all that. So should that be credible evidence and go to a court of law? Must or would the law require that NASA or Honorable Raila Odinga produce the source of the evidence?
Yeah, I think what IEBC, what NASA should do to ensure that their case is very strong, the Supreme Court, if at all they have a case along those lines, is to request under Article 35 of the Constitution and the Freedom of Information Act, the entire ICT infrastructure of IEBC, insofar as the presidential election is concerned. Some kind of a system report, so that they can then compare and make observations that lead to the conclusion that their case is indeed strong. That, to me, will be a sure and credible way to impeach these presidential results. However, to rely on that report, which they have generated externally. We are saying externally because IEBC has said
according to IEBC, there's been no
according to us, the
compromise
report
of
is
the system.
secure. The system is secure. So for evidential purposes, the earlier part looks a bit sure. The other parts where they want to bring that evidence before the Supreme Court will definitely be challenged by Jubilee lawyers, because how did you get this evidence? In fact, you've committed a criminal offense.
By having the evidence with you, or produce the person who gave you the evidence, and they inadvertently would have committed a crime.
Absolutely, and then it will now trigger that continuum of criminal complaints, and you know very well what will then happen if there is evidence that you hacked into the IEBC system and obtained information, as it were.
All right, now the time frames.
Yes.
If this case holds water and goes to the Supreme Court and they take it and need to do that, what are we looking at in terms of time frames? Because constitutionally, there has to be a time frame that the court has to make a decision and either disannul the results or swear in the president. Yes,
if the results are not challenged, then the president will be sworn in. But if the results are challenged, in which which looks a very, very strong likelihood, until the Supreme Court determines that question, and there are rules. And here, let me emphasize, the timelines are very, very strict for the Supreme Court to determine
to make decisions.
To make the decision as to whether the results were accurate or can be impeached. So really, NASA, to me, is running out of time. They should be doing that now. They should have already collected evidence of their agents who didn't sign these forms. Because we hear from the reports on the ground is that right now is when they are trying to make contact with the agents. So they should not run from behind. They should be ahead of this process, because in terms of proving a presidential an irregularity in a presidential election is really a major task. You must come up with evidence, and the evidence must be submitted within the rules which have been provided for by the Supreme Court presidential dispute resolution rules. Remember, the rules are very, very strict. Once they start kicking in, then there's no room for you to introduce fresh evidence when there's no opportunity.
So you need to have everything.
You must have everything. Remember, in 2013, Raila's major famous affidavit was rejected. Yeah. So it is important that they do everything quick and they do everything now. And from the look of things, it looks like these presidential elections is going to be determined on technical question as to whether the IEBC system was hacked or not. And therefore, the court will have to rely on expert witnesses from both sides to make to lead evidence as to whether indeed there was tampering or not. And of course, the evidence by IEBC will also be very, very critical to determine whether the system was hacked. And as we speak, IEBC is already saying our system was secure, our system is okay, it was not hacked.
And I'd like to believe they're making that statement after having verified and assured that whatever evidence that NASA has then would not be admissible.
Absolutely, and because they are in control of the system. They are the ones in control of the servers. They are the ones who have the service level agreements with the service providers, the providers of this software, and therefore they should be in a position whether they tell to tell us how the system is secure and how it was not impeached. And I think also for transparency and accountability purposes, and for IEBC's own for purpose of protecting its own institutional prestige as a body, if I was the chairperson of IEBC, I would really order an immediate investigations. And if I have a report that the system was not impeached in any way, I will share that report with the public.
Okay, just for accountability,
accountability
purposes
and transparency purposes.
Yes, transparency.
Absolutely.
All right, let's look at another major institution that is relied upon by Kenyans as we get closer to the close of this campaign period and election period, and that's the judiciary.
Yes, yes.
They certainly need to be prepared for many suits that possibly they would face. Do you think, and do you feel, are you confident that our judiciary is ready for what may be playing out now?
Yeah, as a legal practitioner, I interact with the court system at all levels, all the way from the magistrates' court to the Supreme Court. And there's one thing which I'm confident, based on those interactions, that the court system is indeed ready for election petitions. Right now, if you, for the past 1 month, if you go to court and you have a criminal case, you have a civil case, you have a corruption case, you have a commercial case which is very urgent, and you want a date in September, October, November, you'll be told by the judges that, you know, we have blocked our diaries for this election, the petitions that we are going to
anticipate.
To determine, and therefore the diary for the court system has very limited room for dispute resolution of other disputes. So the only cases which they are expecting now are election dispute resolution related cases. And remember, they have an internal committee, a judiciary working committee on election preparedness, which has really laid down the infrastructure for dispute settlement. They have clarified everything in terms of what is supposed to be done, in terms of timelines. Election petition cases are supposed to be determined to be heard on a day-to-day basis until conclusion. So I think all that is ready. So from where I stand as a legal practitioner, I think the judiciary is ready. And it is absolutely important for the prestige and the independence of the judiciary for Kenyans to trust these judicial institutions. And really, this message really goes to NASA. They shall not be calling for mass action, because from yesterday's Kalonzo Musyoka remarks, it looks like that is a possibility which they have.
It's one of the options that they
under the table. I think they need to bring all these cards above the table, and the cards above the table require that you play the game fair. You play the game fair by believing in the rule of law and ensuring that at least you give chance to our nascent constitution to be implemented. And how do you implement our nascent constitution? Is that you at least you try and protect the institutions that we have built, IEBC itself, but more importantly, the judiciary. You protect the independence of the judiciary by agreeing to participate and to be subjected to its dispute resolution powers. And that's what NASA shall do. From where I stand, I believe that the judicial system is independent and it will render a just and fair decision to all the parties and all the aggrieved parties, right away from the presidential elections all down to the MCAs.
Okay. Now, for anybody that has a petition or grievance with the election, as we have seen some pop up, what's the time frame? By when do they need to have this submitted? Is it at the point where the declaration is made?
Yeah, I think in terms of timelines and strategy, because it is a question of timeline and strategy. You win an election petition purely because you are ahead of everybody else, and you have collected enough evidence. So in terms of timelines, this is the time. This is the time that they need to collect the evidence and the information. They need to collect the statements of witnesses. They need to collect any video, electronic evidence, anything which they can use to, for purpose of impeaching the results which they are challenging in court. Then immediately after the declaration of the results, because for instance, for the president, once the winner of the presidential election is determined, then the IEBC chairperson is supposed to issue a certificate to that person and also to the president-elect. And if it's the same, then if it's the same president who has been re-elected, then the law still requires that he is issued with a certificate, declaring that he's the winner of that election. Once that has happened, then you were supposed to immediately go to court, to the Supreme Court, to challenge that declaration. For the governor position, immediately the county returning officer, for governor, senate, and county member of parliament, immediately the county returning officer issues the declaration, because you know that after the declaration of these results, the persons will be sworn in. At the county level, there is no room for stopping the swearing in of member of parliament, member of the county assembly, member of a senator or governor, simply because there's a dispute in court. So these persons will actually assume office, they will be sworn in, and they will begin work. So the reason why judges, the judiciary has said that we prioritize this election-related dispute is simply because You don't want these persons to sit in the office for too long, and then later on you disqualify their results. And therefore, it is in the interest of justice and fairness that election results are determined as soon as possible. If I were Parliament, I will make a legislative proposal of some kind of recommendation that before the High Court determines that dispute, no one shall assume office. Because sometimes, once you get into office, there is incumbency. Just like for the presidency, there should be room in law that gives the judiciary some time to hear the dispute and declare whether the election was free and fair, and therefore whether that person was properly elected. But now at the county level, there's no room for that. In any event, if there's room for that, it will also be a logistical nightmare. Because at the national level, you have the Supreme Court and dedicated only to the presidential dispute resolution. But at the county level, you can have numerous cases. For instance, at the High Court level in a county, you can have the case for senator, case for a governor, and case for a member of the county assembly. So if all of them are running concurrently, it will be impossible for the judge then to determine that.
All right.